In 2008, the United States Supreme Court in Heller posed the question whether the framers wanted to use the Second Amendment of the United States Constitution to protect the right to bear arms for citizens other than service in the militia. 5 of the justices, as this court is well aware, said yes. And in 2010, in the McDonald case, the same justices incorporated that right, that individual rather than collective right of an individual to defend himself within his home via the 14th Amendment to the states. Left open by the court at that time was the question of the scope of the right, just what standard would be used in determining legislative validity or not, a lack of validity of regulations on that right, and the limits of the regulatory authority that states or agencies would have in the future over the gun control, firearms control legislation.
Well, you agree that licensing the carrying of a concealed weapon is lawful.
There's no question about that, and that was very clear from the Heller decision. But what was left open, Justice Cordy, was, as I said, the extent of the regulatory restrictions that could be placed upon that particular right.
Do you disagree with any of the restrictions other than the, quote, suitable person, unquote, restriction, or unsuitable person?
This case only raises 2 issues, the question of the suitability category of persons who might be eligible to have a gun license to carry, and it also raises the issue of the scheme, Chapter 141, Section 130, the entire regulatory procedural scheme that, as this court knows, I'm sure from my brief, we are arguing violates procedural due process. So those are the 2 issues in the case.
Could I get some clarification on a point? In one of the amicus briefs, the point was made that possession of a gun inside a home, not just outside of the home, requires this license to carry, which is part of the regulatory scheme. And I wanted to ask you to address whether or not that license to carry is necessary for possession.
That's my first point that I was about to make, but I just wanted to introduce the court a little bit to some of the facts in my case that bear on that issue.
But what is the law?
Well, right now, the law is in flux. There is indications in the Heller case and language in McDonald to the point that they did not say that the question of the application of the Second Amendment to carrying a weapon or self-defensive weapon outside of the home was or was not encompassed by the Second Amendment.
That's not my question. My question is, does this regulatory scheme applicable here require this license just for the possession of a gun inside the home?
No.
It does not.
You just need an FID card.
The regulatory
Isn't that
scheme.
right? It's an
The regulatory
FID card.
scheme here. Excuse me.
It's an
Judge
FID
Gladys.
card. Is that right? That you
That's
need?
correct. Yeah, this particular case arises under Chapter 131 D and F, subsection 131 D and F of the statute. That's the carrying part of the statute.
Right. I'm just
so
saying
in order to
there was one of the amicus briefs suggested otherwise, I think, and I wanted to get clarity on that.
No, my case arises under the carrying 131 D and F, the carrying
That's
license.
only outside
of the residence, outside of the home. The argument, I think, in the amicus also, in the amicus, I think, filed on behalf of the Gun Owners League of Massachusetts, makes an argument relative to the same standard being applied to the suitability requirement to a license inside of the home to an FID type of card inside the home, but that's not raised in my particular case. So, just to give you a quick,
Well, let me move it along, because we're getting short of time. You agree, in answer to Justice Corey's question, that even if there were a right to bear arms outside the home, that one could license those who are allowed to bear arms outside the home, correct?
correct.
And with regard to that licensing, what do you say is the level of scrutiny that we are to give to such a license? The Supreme Court's been silent on the level of scrutiny. What do you say we should infer is
I
the
would
level of
suggest to this court, in answer to the question, Chief Justice, that I would look at it on a two-step process. With respect to the licensing of a person to have an FID card, to have a firearm within the home, I would suggest to this court that the strict scrutiny standard should apply, because the core of the Second Amendment right, as articulated in Heller, is the right to defend yourself within your own home.
But your client is seeking a
My
license
client
to
is
carry.
outside of the home. So my answer to your question is, I think the level of scrutiny could be one notch below, an intermediate sort of scrutiny, where this court could use that particular standard to determine whether or not the regulation under our Massachusetts statute that is at issue here allows for the exercise of that Second Amendment right outside of the home, and at the same time takes into consideration, balances off the interest of the state in maintaining safety.
If it's intermediate scrutiny, your client loses, doesn't he?
No, because our argument, Justice Hines, is that the suitability phrase, that clause, suitable person, especially in the context of his particular case, is so overbroad and so vague that it violates due process.
Well, not as to him. I mean, is it your position that somebody who committed the acts that were attributed to Mr. Holden is under any theory or a suitable person?
The argument is that my client factually was never convicted of a crime, does not fall into any
understand
of the
that.
categories.
I understand
Falls
that,
into
but
the
we have another section of the statute that deals with convictions.
Correct.
So is it your position that if somebody commits acts that could be criminal or could result in a conviction, but doesn't, that person is always suitable?
I am saying that my client, who was never convicted of a crime, whose wife made an accusation against him of assault, who recanted that accusation, and that's in the record.
Well, at the hearing, he
that-
didn't say that he didn't do it. You know, there was no dispute at the hearing. All he said was, what you're saying now, I wasn't convicted. That's not good enough,
I'm not saying
is
that,
it?
Justice Hines. If you look at Volume 1 of the appendix at page 35, you will find Mrs. Holden's testimony. She did testify in this case at the very beginning. And you will find, and I can read it to you verbatim, that when she got on the stand, there was a recantation that my client had ever done anything to her.
Well, did her daughter recant her statement that she made to the police when she made the 911
Her daughter
call?
was not present at the time the incident took place.
She
The
was the
mother
one who
came
made the
into her house
911
and
call.
told the daughter that she had been assaulted by my client. But when the victim, his wife, got on the stand in the district court, the question was put by Mr. Gould, who is here in court with me here today on the other side. Did you make this statement with Officer Rice down here that states you were in an argument with your husband and that he punched you and pulled you out of the car? Answer, this is Mrs. Holden, I don't think that's right. So she denied it, she recanted it, and then
Was there other testimony that might have cast some doubt on the credibility of her recantation?
There was no other testimony other than statements, hearsay statements that were taken by the officer from the daughter, and then statements that were read into the record by the police department at the time of the trial of those witnesses.
There wasn't also
Client?
testimony regarding how she appeared, that she had, had been
There was-
obviously injured?
There was some evidence of bruising,
Right.
but my client's position, and this is also in the record, was that he was driving her car. They got his car. They were in an altercation. She tried to take over the steering wheel, and he had to push her away and get her out of the car to avoid an accident.
Maybe I
But the-
misunderstood your argument. I thought your argument was not that at the time he wasn't suitable. I thought your argument was it may have been indeed the case that under the facts of this case, he was unsuitable at the time. But given only that, let's say, found fact of unsuitability, if there is nothing different for the intervening years, that fact alone is not sufficient for ongoing revocation. I thought that was your argument.
That was the finding of the district court judge, Judge Gardner. And that's how he found, even under the existing statute, Judge Stuffley, that he was arbitrary and capricious because so much time had gone by and he had no further incident. But that's not our argument. Our argument is that on its face, the suitability requirement, which does not spell out with any degree of specificity what the legislature meant, and therefore ties the hand of a judge or even of a police chief when he has to make that determination, leaves it so vague and so overbroad because it encompasses so many different types of behavior. Who is suitable? Who is unsuitable?
Well,
So our
that's
argument is
not
on its face, it's unconstitutional as overbroad and vague.
Mr. Greenberg, but that comes back to my question. How does that matter if under the statute and a proper reading of the statute, your client is not suitable? Never mind the universe of people out
But
there
Justice Sines,
who may be.
we're not accepting your premise. The fact that my client was accused by his wife, with whom he still lives to this day, is still happily married, who recanted her testimony 2 weeks after she made the statement, did not in and of itself render him unsuitable. Now, that's just under the statute, but then the further argument that I'm making that is of far greater importance in terms of the constitutional issues is that because the statute allows a police chief such broad discretion in an undefined category of suitability, that it is vague and overbroad and violates the Second Amendment.
But you don't get to argue that if it doesn't apply to your client, right?
Well, it does apply to my client. That's why he lost his license. He's not had an.
It's not overbroad and vague as to him.
It certainly was, because under the police chief's interpretation of what happened in this incident, he found that my client was unsuitable.
But if you're making a,
And we're saying that.
I was
Just
gonna say,
Pina.
if you're making a facial challenge, is the test whether there is no set of circumstances upon which somebody could be determined to be unsuitable?
I am saying that there are many circumstances under which somebody might be found unsuitable because the definition is so open-ended. I'm saying that the legislation is constitutionally defective because it doesn't spell out with any degree of particularity what unsuitability is. For example, in the recent amendment to the statute that the legislature just put through this year, Section 26 of House 121, they did try to make it a little bit more specific. And they said they tried to define it with more specificity. They said whether the applicant has a history of demonstrating a propensity towards violent behavior, as evidenced by multiple applications of domestic violence complaints. In other words, there has to be, for example, like when you were, as an analogy, the sexually dangerous treatment statute, which has been under constitutional scrutiny for years in this court. There has to be a showing in this statute that the person not only committed a sexual act against the law, but that he had a propensity to use violence and hurt the person in the process, and had some degree of predictability that he would continue to do so. And I'm saying that if the police chief can just say, well, you're just not suitable because somebody has accused you falsely of assaulting somebody, that's not enough. There has to be something more specific.
So are you saying that suitability is too vague, but now with the new legislation, it's no longer too vague?
The new legislation, it really doesn't do much more than what is in the old suitability.
So your view is that if we defined it as they do now, that would not be sufficient?
No, and
What would be a definition of suitability which you would say would pass muster?
I just happen to have the answer to that question, anticipating. Whether the applicant has a documented history of mental illness or emotional instability which has not been resolved by a comprehensive treatment or counseling, whether the applicant has a history of demonstrating violence towards other persons, evidenced by multiple and documented arrests, though that type of language that would make it more specific would cure the present infirmity in the statute. I did, because I know time is of the essence, want to get to the due process issue if I could.
The time is more of the essence. Your time happens to be up, so I'll give you 30 seconds.
All right.
You're already over your time.
In essence, the current statute is an administrative review statute. It places the burden of proof on the licensee who has lost his license. It also does not allow a de novo hearing before the district court. It does not allow a full evidentiary hearing before the court. It is strictly a rubber stamp for the most part, where the police chief comes in with his documentation, puts it on the desk of a district court judge and says, there is a rational or reasonable basis for what I did, affirm it.
It wasn't rubber stamped here, though.
Well, that's what we're trying to undo in this case. I think at the very least there should be a shifting. If this court does find that the exercise of the Second Amendment outside of the home, and I rely on the positive decision, the Moore versus Madison case for that, if this court reaches that issue and finds that the Second Amendment applies outside of the home, and this is a constitutionally protected right, and you apply intermediate scrutiny to the matter, then at the very least you have to have a de novo trial with the right of cross-examination and the right to confront witnesses, all of which was denied my client in this case.
Thank you, counsel.
Thank you very much, Justices.
Now, Mr. Gould.
Good morning, Chief Justice and Justices. May it please the Court, Kevin Gould on behalf of the appellee, Gary Jim, Chief of Police of the City of Worcester. At the outset, I would like to advise the Court that I will be arguing the first half of this argument and that I have conceded the second half to Ms. Kobik from the Attorney General's office. This Court should affirm the decision of the Superior Court as there was reasonable grounds to deny Mr. Holden's application. The Chief's actions were consistent with the statute, and the record establishes that Mr. Holden is not qualified to have a license to carry. Briefly, I would like to address the...
I'm sorry. As I understand Mr. Greenberg's argument, or at least part of it is, that the statute improperly places the burden of proof on the applicant for the license. What do you say about that? Or is that an argument that your sister's going to address?
It's an argument that I think I can handle. The burden of proof is on the applicant to bring forth evidence that there was no reasonable ground. I think this was addressed in the Hightower decision, in which they looked at the due process matter and said that there was no due process issues, both from a pre-deprivation and from a post-deprivation.
But in Hightower, the ground wasn't, I mean, isn't the opinion, that we're talking about the First Circuit opinion, right?
Yes.
Isn't the opinion pretty explicit that what was being addressed was one of the, was not the suitable person standard? Because that wasn't the basis on which the, it was for not reporting a complaint or charges.
Justice Spotsford, it was for a suitability issue because of the fact that it was not one of the disqualifiers in the statute. The denial of that application was for her failure to provide information. That is not within the 7 disqualifiers within the statute. That is a suitability issue. That was what the revocation, or the denial was for.
Wasn't it sort of based on the Boston Police Department's extra added attraction to the,
That's correct.
which had that as a specification?
That's correct, but at the same time, it didn't fall within the 7 specific statutory disqualifications, so the only other way you could revoke that license is through the suitability clause. Just briefly on the facts of this matter, I think it's pretty clear, and the evidence is pretty clear on the record, that on September 10th, 2005, Mr. Holden was involved in a physical domestic altercation with his wife in which he punched her in the face.
But let's accept that. The question is that a permanent disqualification?
I would say,
Anything, you know, it's a different story where, you know, you fail to provide information on a particular application, something that can easily be remedied at some point in the future. How do you remedy what happened here? Can you ever, I mean, is this just, you know, an 8th de facto disqualification?
it's on a case-by-case basis, and I think the licensing authority needs to look at these matters on a case-by-case basis and determine whether the individual who's...
What does that mean, a case-by-case basis? So like here, you're saying it's acceptable, and in this situation in 2000, what is it, 2006?
2005.
2005 to take away the license, and then refuse in 2010, again, on the same grounds, nothing else has happened. And so in 2015, 2016, it will be acceptable also to do the same thing?
I would point to the Chief of Police of Leominster versus the Leominster District Court case, which I've cited in my brief. And in that instance, it was an individual who had their license denied following an incident from 20 years past in which they had waved a gun outside of a window of a car. And the appeals court said in that decision, it's an unpublished decision, but said nonetheless that...
What year is it?
It is...
I mean, I guess my question really is it before Heller and McDonald or after?
It was before Heller and McDonald. I concede that.
Does Heller and McDonald have any impact on the regulatory scheme?
I don't believe it does, because I believe that suitability is the same thing as what Heller determines to be a qualified individual, a responsible individual. In the Heller decision, the Heller court said that that the Second Amendment right applies to law-abiding, responsible citizens. And at the very end says, assuming that Mr. Heller is not disqualified. So if you're looking at it from that, under Heller, you clearly need to be qualified before you are afforded that Second Amendment right. Suitability is qualifications. This court in Chardon stated that the goal of the firearm legislation was to ensure the licensure of those who have proven qualifications. So to that end, you have to be qualified, you have to be responsible. And Mr. Holden does not fall within that category of individuals based on his actions on September 10, 2005.
So back to Justice Lang's question, is that a permanent disqualifier?
I think it depends on the licensing authority. I think to some end...
You mean in Worcester, they could do it, but not in Quincy, because you have different police chiefs and the same set of facts?
I think his actions make him unsuitable on that date, regardless of when they occurred.
So there's nothing to be worried about if there is a great disparity in the way people are treated on seemingly similar facts, depending upon who the police chief happens to be and his or her own attitude about how strictly to construe the notion of suitable person?
In this instance, where there's credible, reliable evidence of a physical domestic assault, where the applicant is the perpetrator, I think that the chief of police, the licensing authority, is directed under the statute to ensure that that individual does not have a firearm to protect the public safety.
5 years ago, 10 years ago, 15 years ago.
So the chief of police has to hold an evidentiary hearing with the victim in these cases?
No.
Well, how do you know it's credible evidence?
In this instance, if you look at the facts, you have a signed sworn statement from the wife.
It was recanted.
It was recanted, and I think anybody
If he had been found not guilty, would the result be the same?
I think the result would be different. But he wasn't.
Well, why would it be different? I mean, so that the Commonwealth hadn't sustained his burden of proof beyond a reasonable doubt. Should the chief of police, or could the chief of police hold an evidentiary hearing and conclude that by a preponderance of the evidence, there was a domestic incident?
Sure, and a chief of police could do that.
Shouldn't that have happened here?
I don't think the statute requires it because there are such adequate post-deprivation procedural due process.
So let's say, what would you say if, let's say, I know he didn't, but Mr. Holden at the hearing before the district court had actually testified, and the judge found him credible and said, you know, I don't believe this I don't believe this happened. I believe him when he says it didn't happen. Is that a ground to reverse the chief?
That would be, if the district court judge determined on the credible evidence before him that there was no assault and battery that occurred, then we'd have to live with that.
So, and you say that's fine, putting that burden on the applicant, well, or the person whose license is getting revoked before the chief, so.
That's correct.
All right, thank you.
Thank you.
Good morning, Your Honors, and may it please the Court, Assistant Attorney General Julia Kobik for the Commonwealth. I'd like to turn to Justice Lank's questions to begin. I don't think that the suitable person standard or the facts on this case resulted in a permanent disqualification of Mr. Holden from obtaining a license to carry. Mr. Holden had the opportunity to introduce evidence that in the intervening 5 years, he had proven that he was not a public safety risk and that
How could he do that?
he,
How do you prove a negative?
He could have had his wife testify. He could have testified himself. He could have introduced evidence that he had taken an anger management course. He had the opportunity to introduce plenty of evidence that he was no longer a risk to public safety and to his wife specifically, and he chose not to do that. And I would point out that he has the opportunity to apply again for a license to carry in the future, and again, he could sustain that burden if he chose to do so. But on the facts of this case, the chief did not find that there was a permanent disqualification. The chief simply found that he had no reason to believe that Mr. Holden was no longer a public safety risk given the severity of his conduct 5 years earlier. So I don't think this case is a permanent revocation case or permanent disqualification case. It's just on these particular facts, Mr. Holden's conduct was severe enough that the chief appropriately determined that he was still unsuitable to obtain a license to carry.
You know, typically, when we're taking something away from somebody, when the government is taking something away from somebody, the burden of proof is on the government.
Right.
Revocation of parole, revocation of a driver's license, revocation of welfare benefits. Why here is the burden of proof on the applicant? I shouldn't say the applicant, on the licensed person.
I think the legislator could have appropriately chosen to place the burden of proof on the applicant, on Mr. Holden here, once the chief has some
How can the
evidence.
legislature justifiably place the burden of proof on the license holder?
Well, the locus of the burden of proof typically is not a matter of procedural due process rights, and I'd cite the court to a 2005 decision from the Supreme Court, Schaefer versus Wiest, which is at 546 U.S. 49. The court said, outside the criminal context and for due process purposes, the locus of the burden of persuasion is normally not an issue of federal constitutional moment. I'd also add that to the extent the court is worried about the location of the burden of proof in this case, this is not a good vehicle for considering that issue because the burden of proof only comes into play when evidence is in equipoise. And here, the evidence was wholly imbalanced. There was evidence introduced by the chief of the assault. It was supported by the daughter's 911 call, the statement to that Mrs. Holden made to the police chief, the police report. On the other side of the ledger, Mr. Holden only introduced evidence of the docket in his criminal case and the chief's policy. So the evidence was not balanced in this case, and the burden of proof would not affect the outcome. But just as a more general matter, I don't think it's too much to ask Mr. Holden or any applicant to come forward with evidence that they don't pose a risk to public safety once the chief has found credible, reliable evidence that, in fact, the applicant does.
How can the chief find credible, reliable evidence if there's no evidentiary hearing?
The chief was permitted to rely on police reports, and he did so in denying Mr. Holden's license to carry, but then there was an evidentiary hearing in the district court. The statute.
Does that alter the balance generally? I mean, is there a requirement that there be such a hearing?
There is a requirement under Section 131F that once the applicant who's denied seeks judicial review, that there will be an evidentiary hearing, and the applicant then has an opportunity to put on witnesses, to
And that
cross-examine.
evidentiary hearing, excuse me, takes place in the district court?
In the district court, that's right.
Okay.
Yes.
And
Is it your view that the carrying of a firearm outside of the home is a privilege, or is it an entitlement that the government can take away only for good reason?
I don't think the Supreme Court has affirmatively held that there is a right to carry a firearm outside the home. And I think, as Mr. Greenberg agrees, that the licensing provisions are perfectly acceptable and at most subject to intermediate scrutiny. So I don't think that issue.
Are you saying it doesn't matter in terms of our review of this case, whether it is a privilege or a right?
I think it's more like a privilege, but this court could assume that some Second Amendment rights apply in this case, and then still subject the suitable person standard to at most intermediate scrutiny. And under that standard of review, which Mr. Greenberg has agreed would be the highest standard of review that applies, the suitable person standard is perfectly constitutional. It advances a clearly important government interest in promoting public safety and preventing harm to the citizenry, and it's substantially related to that interest because the licensing statute has certain categories of persons that are disqualified because they pose an especially high risk to public safety, but the legislature appropriately determined that those categories can't screen out everyone who would pose a risk to public safety.
if you assume that there is some quantum of constitutional right involved in carrying outside the home, does that bring with it a requirement that suitability be better defined? I mean, I know your argument about vagueness and overbreadth doesn't apply outside of the First Amendment context, but at some level, is there a requirement that there be a better definition of what suitability is?
I think, no, Your Honor, I think these are separate issues. So one issue is, how does the Second Amendment analysis work in this case? The second issue is the statute void for vagueness as applied to Mr. Holden? And I think the answer is no there. When a term like suitable person is not defined in the statute, this court has said you look to the purpose and you look to judicial decisions that clarify its meaning. Here, the statute, the purpose is clear. It's designed to keep firearms out of the hands of individuals who wouldn't use them responsibly. And then the statute is over, or the standard is over 100 years old, and there's been many, many decisions.
But can I ask you this? We noted in the Simkin case a year or two ago that there really was no definition in the regulatory context or the statutory context of what a suitable person was or an unsuitable person was, clearly urging that there be some further clarification. The legislature then enacted this Acts of, was it Chapter 284 of the Acts of 2014, saying a determination of unsuitability shall be based on. Okay? So does this in some respect limit what can be considered unsuitable?
I think that is a question for a future case because this new statute doesn't apply to the facts of this case. I would contend that I don't think all of this court's case law and lower court case law interpreting the suitable person standard should be thrown away, but whether the new text of this statute is exactly consistent with the term suitable person in the prior statute, I think is a question for a future case.
Okay, thank you.
Thank you.
All right, thank you.